Hi everyone, welcome to another podcast, Family Matters. And as you know, we discuss a wide range of topics, and today is no different, although this also has a family first angle, but actually it's something much more deep, much more important, and that's around the role of our court. So I'm very pleased to be joined by Roger Partridge. He is the chair of the New Zealand Initiative, one of their senior research fellows, and he's just published a paper called Reining in the Supreme Court. So Roger, welcome to the show.
Hello.
Hey, talk us through this piece of research. It's generated a lot of discussion, and its basic premise, as I understand it, is that the courts, where they're meant to sit in our constitutional structure, particularly with Parliament, might be going a bit awry. And you've raised at least 3 points, but give our listeners a bit of an insight into what you've researched and what your conclusions are.
Yes. Well, the report examines the growing power struggle between Parliament and the courts. Or at least the courts and Parliament, because it's the courts that are trying to wrestle power off Parliament. And it has potentially far-reaching consequences for our democracy and what lawyers call the rule of law. And for non-lawyers, the rule of law means things like the impartiality of the courts and the consistency and predictability of judicial decision-making. The problem stems from a series of increasingly misguided decisions by New Zealand's highest court, the Supreme Court, which sees the court blurring the lines between judges' traditional role of interpreting and applying the law in particular disputes between particular litigants before the courts, and Parliament's job of making laws. And we know Parliament's laws, we talk about them as acts of Parliament or statutes, legislation. Parliament's job is largely a forward-looking one. It makes the laws for the future, sets the rules of the game. The court's job is largely applying those laws and applying what we call the common law, principles derived from cases that have been decided over the centuries. So interpreting those principles and laws and applying them to the particular disputes between the parties. So Parliament's role is essentially a forward-looking one, and the court's role is essentially a backwards-looking one. But we're seeing a blurring of the lines without courts increasingly seeing themselves as lawmakers. And there's a cautionary tale from the United States. It's discussed by Professor Richard Eakins from Oxford in his foreword to the report, where we see what happens when judges become lawmakers and effectively politicize the judiciary. We end up with laws that are less certain and predictable because they will depend on a court's particular views about the direction it wants to take the law. It leads to less trust in the impartiality of the judiciary, and it leads to an erosion in the democratic legitimacy of the legal system. And our Supreme Court seems blind to these risks and intent on taking our legal system down the same dangerous path. At the moment, we're blessed, or we have been historically blessed with a very impartial judiciary, and probably ordinary New Zealanders would know the names of US Supreme Court judges more than they'd know the names of New Zealand Supreme Court judges. Because the US Supreme Court plays this outside lawmaking role and effectively has politicized the judiciary. And that's something we must avoid in New Zealand. And the report looks at how that's come about, what the court's doing, the ways in which the court's moved outside its lane and into Parliament's territory, the perils of that, and then what Parliament can do to get the court back in its lane.
I think what you've researched and articulated is actually incredibly important. As you know, I'm no lawyer. That's your expertise and background. But, even in my time in Parliament, began to see this, as I deemed it, an overreach. Maybe you could draw out a couple of examples for our listeners. I mean, and I'm probably going to use the wrong terms, Roger, but the court's come out with various, determinations? They've just made statements like the Keep It 16 campaign. They decided to opine on what Parliament should do. They reinterpreted, I thought rather creatively, the notion of parliamentary privilege at one point, which forced us back into Parliament to fix that. And more recently, they've done some changes around, 3 strikes? I mean, could you just illustrate for listeners and viewers just what some of these cases are where Parliament has reinterpreted what Parliament has intended?
Yeah. So we're seeing three things, really. We're seeing the court increasingly keen to engage in matters which I think most people would regard as matters for Parliament, political matters. The Make It 16 case was the voting age case, a case brought by on behalf of 16-year-olds wanting to vote. The court intervened in that case. It's a highly politicized issue because, as most people will know, when you poll 16-year-olds, they overwhelmingly want to vote for the political left. So it's got danger written all over it. The court decided that the Electoral Act, which preserves voting rights just for those aged over 18, breached the freedom from discrimination provisions of our Bill of Rights Act, which prohibits discrimination on the grounds of age. And they made a declaration of an inconsistency that a breach of the Bill of Rights doesn't involve an act being invalid like it does in the US, because we don't have a written constitution. And the Bill of Rights is just an ordinary piece of legislation. But it was dangerous territory for the court to go in. What's worse is, in their enthusiasm to intervene, they got the law wrong. The Bill of Rights defines, well, age is defined for the purposes of the Bill of Rights as any age over 16. And the Bill of Rights then goes on to say that to protect the voting rights only of 18-year-olds. So the Bill of Rights expressly addresses the issue of voting rights and only protects voting rights for those aged over 18. So it's quite a bizarre conclusion the court reached. It tied itself up in knots in concluding that the Electoral Act, in protecting voting rights, preserving voting rights just for those aged over 18, was a breach of a general provision of the Bill of Rights about age discrimination, when the Bill of Rights itself only protects voting rights for those aged over 18. So they got themselves tied up in knots in that decision. The correct outcome is that the Bill of Rights, the correct legal position ought to have been that the Bill of Rights directly addresses voting rights and only preserves voting rights for those aged over 18. And that was the view of the minority judge, Justice Koch, but the majority tied themselves up in knots.
It might be a mischievous question. Sorry to jump in, but is it that they see a great moral duty to try and override what Parliament says? Because as you've articulated, and again as a former parliamentarian, the law was really clear in black and white, and you say they tied themselves up in knots. Is it they see a moral imperative, or is this sort of just academic almost? They want to have some, again my term, a judicial fun, Roger, that let's try something creative. I mean, what's the motive here, I suppose, is what I'm asking.
Well, I don't want to speculate on the judge's motive. Let's just look at what they're doing. There are two key areas where there are problems. The first is when interpreting Parliament's words in statutes or acts, they've given themselves a lot of license to only loosely follow, and sometimes even to ignore, what Parliament said when the courts don't like the outcome. And that's not the court's job. The court's job is faithfully to apply the law. They're given some leeway, and of course sometimes Parliament doesn't do a very good job, and laws are ambiguous, and they need to work out what the meaning of what Parliament intended. But more generally than that, they've given themselves a lot of license to sidestep relatively clear words used by Parliament. That's the first area where we've got a problem. And the second area concerns the common law, as I mentioned, the body of legal principles laid down over centuries in decided cases, where traditionally the court's role has been to, well, work out if apply the principles that are laid down in the body of cases. Sometimes those principles might be in conflict in a particular circumstance, and they need to iron out wrinkles in the common law. And sometimes there are parts of the common law that don't apply, that there are gaps in the common law, and they'll sometimes fill the gaps. But our Supreme Court has been saying now for nearly a decade or more that their task is to develop the common law, to take it on a journey to respond to their views of society's changing values. There's a real danger in that, though, because unlike Parliament, the courts aren't at all equipped to work out what society's changing values are. They don't have a law commission to do a big investigation. They're not subject to the submission-making process where anybody with an interest can make a submission. And even more than that, they're not democratically accountable if they get their decision wrong. So if Parliament makes those big social policy decisions, voters have a chance to say, no, you took the law in the wrong direction, and vote parliamentarians out. So our judges don't have the tools to make big social policy questions, and they don't have the accountability to make those social policy judgments. And the risk is that people start to feel that when the court says it's changing the law to match its view of society's changing values, that it's really changing the law to match the particular judges in the court's values. And that politicizes the judiciary, and there's a grave danger in that. We don't want our judges to be coming into the courtroom with an agenda. And that's what we see in the US, and that's the path the court's taking us down. So cases that illustrate those two problems, well, one is the three strikes legislation passed by national government, which said that it's a third strike offender, charged with committing a third serious crime and convicted of committing a third serious crime. The three strikes provision, Section 86D of the Sentencing Act, required the court to impose the maximum sentence. And it did that in language which was couched as despite any other enactment to the contrary. And the court decided, despite that clear language, that didn't include the New Zealand Bill of Rights Act. And the New Zealand Bill of Rights Act protects people accused or convicted of offences of being subjected to unfair or harsh punishment. And in the Fitzgerald case, the three strikes case, Mr. Fitzgerald's third strike crime was a relatively minor offence. It was a sex offence. He had kissed a woman on the cheek. And you can understand people thinking, well, it's tough for him to get the maximum sentence for that offence. But that was clearly Parliament's intent. Mm. And the court sidestepped what Parliament clearly meant. There was a strong dissenting judgment from Justice William Young, who said that the words despite any other enactment and on any occasion and the High Court must, those were all terms used in the relevant provision. He said they seem to admit of no ifs and no buts. And he saw what the court did as rewriting the law, not interpreting it. Mm-hmm. And it's very hard, despite whatever you think of the three strikes law, and I'm, for one, am not a great fan of it, despite what you might think of it, it was Parliament's prerogative to pass the law, and it was the court's duty to apply it. And the problem with the court deciding, well, we don't like the outcome, so we're going to interpret our way around it, is that the uncertainty that creates in what the law means.
And look, that's one of the, for me, you've had a number of critical points. It is that uncertainty. But as you say, it is for Parliament. That's our system. And I don't just say it having been there, but those are the elected people who make the decisions, and you and I and society don't need to agree. But it's there, and as you say, for the courts to interpret. And I think importantly, and please correct me on this, the judges can look not just at the law itself, but also at the Hansard or the written record of the various speeches from what the minister and others intend to give context. And I can say very clearly with the three strikes law, also been a little bit uncertain on it myself personally, it was clear Similar with the Marine and Coastal Act that's been rewritten by the government at the moment because the court took a rather creative interpretation of what I think it was exclusive meant. And I suppose for viewers and listeners to understand, again, it doesn't matter if you agree or disagree with what's happening. The court was very, would you say, creative, Roger, in how it chose to interpret, or did it just ignore?
Well, in the Marine and Coastal Area Act case, it was the Court of Appeal, not the Supreme Court. But yes, the Act said for iwi to establish title to a marine and coastal area, they had to have had exclusive and continuous use, and the Court of Appeal said exclusive could be shared exclusive, which is slightly oxymoronic, and continuous could be interrupted. And this is an example of one of the Parliament's response to this is an example of one of the recommendations we make in the report, which is to pass legislation overturning wayward decisions, to send a clear signal to the courts that Parliament means what it says. So that's one area. Statutory interpretation is one area where the courts are going off the rails. In Fitzgerald, slightly concerningly, I'll get into this is another technical detail here, but Section 6 of our Bill of Rights Act says that where an enactment that infringes a right protected by the Bill of Rights, where it can be given a meaning that's consistent with the rights and freedoms contained in the Bill of Rights, that meaning shall be preferred to any other meaning. So if you've got words that can be given a meaning that complies with the Bill of Rights, then the courts are to choose that meaning. Now, up until the three strikes case, Fitzgerald, the court had said, well, that's all very well, but the meaning still has to be reasonably available. Otherwise, we're rewriting. And in Fitzgerald, the majority said, no, the word reasonable doesn't appear in Section 6. So the courts don't have to adopt a reasonable meaning. They can adopt, I suppose, by implication, an unreasonable one. And that was certainly never Parliament's intention, that the courts would adopt an unreasonable interpretation of Parliament's words. Parliament's duty when interpreting legislation is to ascertain its meaning from its text and in light of its purpose and its context. And as you say, context can include the debates about, and hence the parliamentary debates. What was the mischief the legislation was trying to fix? It was perfectly clear in the three strikes case, but the court decided they could interpret their way around it. So that's one problem. The court's taking an extravagant or lax approach to applying laws passed by our democratically elected parliament.
Which I might add actually becomes quite costly. This is not the biggest or most important argument. You've articulated the tensions, but people have to understand every time that the Parliament has to sit and re-engage these laws, like three strikes, like what they call MACA, the marine and coastal areas, this is time and taxpayer money to try and make even clearer, and I'd stress that, even clearer, what was already in the laws. But I interrupted you on the second point, which I suspect is around sort of societal values.
Yeah, so this is so there's three sources of law. Statutes, laws passed by Parliament, the common law or judge-made law, made up of derived from decided cases, court decisions over several centuries, and you can extract a body of principles from them, and they're articulated in textbooks, and they should be then applied by the courts. So that's the common law. And then there's custom, and custom can give rise to legal rights if a local or general custom meets certain requirements, including the custom being a long-standing one and it having a clear and objective meaning and application. So in relation to the common law, so the middle category, judge-made law, what we're seeing is the courts increasingly explaining their role as one of taking the law on a journey. And there's no reference in the legislation setting up the Supreme Court to develop the common law or to take it on a journey. Instead, the Supreme Court Act 2003, which established the Supreme Court, and the Senior Courts Act, which now consolidates the Supreme Court Act. Those acts both refer to two things: New Zealand's commitment to parliamentary sovereignty, which is impinged when the courts are lax with interpreting Parliament's words, and a continuing commitment to the rule of law. And critical elements of the rule of law are consistency and predictability. And we don't have that if the courts see their role as taking the law on a journey to develop it in along the lines or in accordance with the current judge's views of society's values. And a good example of that case is the Ellis decision from 2022, where the court overturned a long-standing rule for the recognition of Maori customary law, or Maori custom, tikanga, as law, and said that now tikanga forms part of the common law and any issue before the courts might need to be looked at through a tikanga lens. And that's thrown the law into disarray because it's now unclear on a case-by-case basis what influence the Supreme Court now thinks tikanga plays with settled legal principles. And we're seeing that they've created a quagmire. Even the Law Commission observed that in the Ellis case, which is concerning Peter Ellis, the new approach of the court they threw out the existing provisions or rule for the recognition of tikanga or custom as law, but replaced it with nothing. And so we've got a big social policy decision, the role of tikanga in the law, being made by the courts and leaving a high level of uncertainty, a lack of predictability about what the courts future courts are to make of this. It was made worse by the fact that when the Ellis decision, for the Supreme Court's decision in Ellis was laid down, the government had asked the Law Commission to look at the proper role of tikanga in the law, and the Law Commission subsequently produced a very large report on it for Parliament to consider, and if Parliament thought appropriate, develop a statutory scheme for the recognition of tikanga. But the Supreme Court barged in, and in their enthusiasm to play a role, have left us with a mess. And it shows all the problems with the court's view that its role is to develop the law. They're not equipped to develop the law. They're equipped to decide cases, disputes between particular litigants. They're not equipped to set out schemes for large-scale changes in the law, and nor are they democratically accountable for those decisions, like our parliamentarians are. So Ellis is a paradigm case of the court charging in an area it should leave well alone.
And as a layman, it came out of left field. The Ellis case wasn't strictly about tikanga, but they decided to introduce it, my terminology here, through the back door. And as you say, the uncertainty, as I've talked to different lawyers and even some judges, there's a lot of uncertainty. And that's the whole point of law, isn't it? It's, if you will, black and white. Everyone knows what it is and it can be applied. If you don't mind, it'll be also of interest, and I don't want to go into the depths of the case, but obviously Family First has a bit of an interest in this, and you referenced it because the judge, you talked about societal values. In that particular case, said actually the role of family has changed, and therefore the charitable purpose has changed. And that's an example of, again, how a judge is moving the goalposts. As you say, not an originalist interpretation of the law, but saying, hey, society's changed, or rather I, the judge, have decided the values have changed, and therefore I'm going to adapt accordingly. And that's sort of quite dangerous. And for me, Roger, at least two levels. One, who is deciding what is societal change and what is good and appropriate. But also, as you've mentioned, it's an unelected person making these decisions. So that should be of concern to us too.
Yes, the Family First case could well have been another case study in the report. It's not a decision I'm as familiar with as either the Ellis or Fitzgerald cases and a few others of the Supreme recent decisions of the Supreme Court. But I cite it as an example where the courts have said that their task is to develop the common law based on the court's perception of changing societal values. And what you had in that case is the court changing the test for what is or what isn't a charitable purpose. And you're left, and one of the requirements is that, yes, it's fine to be educating. A charitable purpose can be educating the public on a particular social policy issue, but they said that the approach can't be pure advocacy. It must be education and therefore must be balanced. And the court concluded that Family First, as I understand it, the court concluded that Family First's approach didn't meet that balanced threshold. Now, the case is puzzling because there are many other charities that are not just education groups, but advocacy groups. You only need to think of Greenpeace, ASH, or anti-liquor bodies, organisations. And one wonders whether the court would have taken such a critical view of, say, a climate change activist group as it did of Family First, and required the other side to be put in the advocacy, or require the organisation to put the other side of the argument, if there is one.
And, well, that's an example, potentially, isn't it, of that politicization, whether real or perceived, when it starts moving into this space.
That's right. And it's possible to see the Family First decision as one where the court set a higher standard for an organisation whose views perhaps didn't match the court's, or at least whose views didn't match the court's perception of society's changed values. And so it's susceptible to criticism that the court set a higher standard for Family First than it might have for another organisation. And that's certainly very unfortunate, because it's precisely that politicizes the court system.
It also illustrates for me that uncertainty. If the court is going to say, look, we can judge or perceive what societal values are, which kudos to them. I think as a student of philosophy, we spend most of our time trying to work what those values are. But if they can determine them and say that we can interpret for now, it also brings in massive uncertainty, Roger, for the future, because next year, the year after, they could reinterpret again.
That's right. It raises the rule of law problem that I identified at the outset, which is one of the major values that our legal system is committed to, and that the courts are required to uphold. So, in the aftermath of Family First, the Family First decision, for example, how do organisations predict with any certainty what will qualify as sufficiently balanced advocacy as required by the Supreme Court's test? And I think a fairly strong argument can be applied that can be made that different standards will be applied to different advocacy or interest groups. And that undermines, as you say, the certainty and consistency, impartiality and predictability that are fundamental to the rule of law.
So how do we change this? I know in your research and your report, you've put out a number of suggestions. One is certainly that Parliament takes back control, although you might want to elaborate, well, even for me, as much as viewers, of what that might look like. But yeah, what are some of the solutions that you are suggesting to address this matter?
So the report makes 5 recommendations. They can be grouped into 3 categories. The first is that Parliament shouldn't hesitate to intervene and pass legislation overruling the most aberrant or wayward decisions of the court. It's Parliament's job to set the course of the law, And if it thinks that the Supreme Court's taken it off in the wrong direction, Parliament should step in and either clarify or change the law. The Labor-led government did that following a decision of the Supreme Court in D and the police, which concerned the Child Sex Offenders Register, and the Supreme Court decided that it wouldn't interpret the law as applying retrospectively to Mr. D. That Parliament said it considered it that's what it had meant, and it passed legislation under urgency, clarifying, if you like, that the law meant what it said. So, and Parliament, as you've said, is currently proposing that in relation to clarifying the meaning of the Marine and Coastal Areas Act case. So that's the first, and it's the most blunt instrument that Parliament has to correct a wayward Supreme Court. In the past, decisions by Parliaments passing acts to overturn the outcome of cases have been relatively rare, but that's because in the past we haven't had a Supreme Court intent on taking the law off on a journey, and a court that is determined to make big social policy decisions in its decisions, and effectively take that role off Parliament, can expect to be reversed more often or overruled more often, and I think we'll see more of that. So that's the first. Mm-hmm. The second group of recommendations are for Parliament to impose stricter guidelines on the courts and their approach to interpreting Parliament's words. Parliament does set rules for the approach the courts are to take when interpreting legislation, acts of Parliament, statutes. And the Legislation Act provides, as I've mentioned, that the meaning of legislation must be ascertained from its text and in the light of its purpose and context. Parliament doubtless, by referring to context, Parliament doubtless means the context that existed when legislation was passed. The Legislation Act doesn't say that. So it's susceptible to a current view amongst many, the judges included, that the context of legislation can change as the court considers society's values change. We recommend that the Parliament knock that on the head by making it expressly clear that the context is the context when legislation is passed. The second legislative guideline we recommend is to define what Parliament means by the rule of law. I've referred to that a few times in this discussion, and its traditional view is that the traditional view of the rule of law is that connotes issues or values like consistency, predictability, impartiality, knowability in advance, and so on. So formal characteristics of laws. So the requirements that laws need to have to be regarded as laws. There's another school of thought that the rule of law now includes social justice considerations, and that view is prevalent amongst some of the Supreme Court judges. And because the Senior Courts Act affirms New Zealand's commitment to the rule of law, that provision could be manipulated to support the court's view that it can take the law on a journey to achieve social justice. Social justice is really the wheelhouse of Parliament. And so we recommend that Parliament should define what it means by the rule of law and narrow them to refer to the formal characteristics of law. It was certainly never Parliament's intent in confirming its ongoing commitment to the rule of law that Parliament would use that as a way of developing the law to meet the judge's views of society's changing values. And so we think that the Parliament should specify a narrow definition of rule of law. And then thirdly, in relation to Section 6 of the Bill of Rights Act, that's the one that I mentioned earlier, which provides that the court can adopt, if there's ambiguity, a court can adopt a meaning that's consistent with the Bill of Rights. This is the meaning of legislation. Parliament should make it clear that that meaning has to be reasonable, and that any interpretation the courts adopt can't go against the clearly expressed intent of Parliament. So that's the second category of reforms. So that's tightening up the statutory guidelines that the courts must follow when interpreting legislation. And then the third category relates to judicial appointment processes. And this is partly a message to the Attorney General and partly a message to Parliament. There are two recommendations in particular. The first is that in making appointments to the senior appellate courts, the Court of Appeal and the Supreme Court, that the focus should be on judges who have shown judicial restraint and respect for the sovereignty of Parliament. And that doesn't mean politicizing, making political appointments. It far from it. It just means appointing judges that have shown by their decision-making processes a commitment to the rule of law and the sovereignty of Parliament, two important values enshrined in the Senior Courts Act. And then the second reform to judicial appointment processes is to suggest fixed terms for our Supreme Court judges. So they're the judges in our highest Court of Appeal, the Supreme Court. At the moment, when they're appointed until age 70. What we're suggesting is terms of 5 or 7 years, fixed terms, so the judges will come up out of the Court of Appeal into the Supreme Court, spend 5 to 7 years there, and then go back into the Court of Appeal. And that way they'll be more grounded in judicial decision-making. The Court of Appeal hears hundreds of cases a year. The Supreme Court hears only about 20. So it will ground judges and take our Supreme Court judges away from the very rarefied, perhaps ivory tower, if you like, environment of the Supreme Court, or only leave them there for a term. And there are many countries in the world where constitutional courts, the highest courts, have fixed terms for judges, and we're recommending that.
Sounds like, look, pragmatically to me, a lot of it makes sense. The issues you've raised in your paper, and one of the key reasons to bring you onto the show, it strongly resonated with me, first and foremost, just as a New Zealander, but also through my parliamentary experience, where that, if you will, tension, my word, between Parliament and the courts is building. And so much, again, I probably have this wrong, but this whole notion of comity, this respect between the branches, between Parliament and the courts, it feels at times, Roger, it's only going one way. And yeah, a lot of what Parliament's trying to do has been thwarted, and bringing, as you've mentioned a few times, that uncertainty. So look, thank you for doing the research and articulating not only the issues, but also the solutions so clearly. How do people listening best find your report? You must have a website, of course.
Yes, they can find the report. It's available for free at the New Zealand Initiative's website, www.nzinitiative.org.nz. You'll also find links to the webinar that which we ran last week. That was Oliver Hart, which convened it, our executive director, with Jack Hodder, KC, a senior King's Counsel, and me. There are various other podcasts, and there are various columns in the media, all freely downloadable, along with the report itself.
And so can I recommend to viewers to do so? The New Zealand Initiative's website, very easy to access, a whole range of actually research, not only this, and as Roger's also indicated, there's a whole lot of other forums. So Roger, look, thank you so much for your time today. It's been great having you on to talk us through, and again, thank you for your research.
Thank you, Simon. My pleasure. Thank you for having me.